We have two major legal updates this week, one on the Tickle and Giggle case and one on the Lesbian Action Group against the Australian Human Rights Commission. Firstly, Tickle and Giggle. On the 15th of January, Giggle representative Sal Grover appeared on Sky News to update that Roxy Tickle has counter-appealed the federal court's decision last year, the decision that was in his favour. His argument, if successful, would likely result in being awarded higher compensation. Giggle has said that it has filed its own appeal challenging the federal court's definition of sex in the Sex Discrimination Act as being legal sex rather than biological sex, and arguing that the judge erred in finding that the Giggle app was not a special measure to advance women's equality. So Giggle is challenging both of those. Grover updated that Tickle, however, has counter-appealed, and he is challenging the finding that his exclusion from the app was only indirect discrimination rather than direct discrimination. So the court found that Sal removed him because she perceived a man based on his appearance, and that this criterion of having a feminine appearance indirectly discriminated against trans women on the basis of their gender identity. Effectively, that they were legal women with the gender identity of trans women, and that expecting women, legal women, to have a feminine appearance would treat trans women unfairly. Tickle is appealing that and arguing that it was direct discrimination. In other words, that he was removed because of his trans identity, which essentially argues that Sal knew that he was a trans woman and not a man when she removed him, and that it wasn't just a byproduct of him looking too masculine. The Australian Human Rights Commission is intervening as it has a statutory right to do so. Additionally, it seems that the Australian Christian lobby is also applying to intervene, although they will need the full court's permission. The ACL application, as they argue that the case touches on fundamental questions of freedom of association and the right to maintain spaces based on biological sex, which they assert should be upheld under the law. So it's essentially an intervention on the side of Giggle. The first administrative hearing is on the 12th of February. The second major case update is in the Lesbian Action Group against the Australian Human Rights Commission, so LAG against the AHRC. On Monday, the Lesbian Action Group received the decision of the Administrative Review Tribunal in its matter against the AHRC. In 2023, you might remember, LAG applied to the Commission for an exemption under the Sex Discrimination Act that would enable it to hold female-only, lesbian-only public events and be protected from discrimination claims against it. The Commission at the time refused to grant the exemption, and LAG challenged that decision in the tribunal. It was represented by the Feminist Legal Clinic, staffed entirely by unpaid workers such as Principal Solicitor Anna Kerr and Barrister Lee Howard, acting pro bono. The tribunal affirmed the Commission's finding and refused to grant the exemption. LAG was denied legal authorisation to hold biologically female, lesbian-only public events. The tribunal described lesbian women, LAG specifically, who define themselves by biology and wish to publicly organise along those lines as a subcategory of the broader legal category of lesbian women, which includes men who identify themselves as lesbian. It found that seeking to exclude these other lesbians would be improperly discriminatory and not allowed under the Sex Discrimination Act, not something that they would permit with an exemption. The final section of the decision summarises the key part of the reasoning. The tribunal member says, in summary, the applicants identify as a discrete minority within a group in the community that is already identified by their sex and sexual orientation, characteristics that afford them the protection of the SDA. They seek to actively discriminate against another group in the community identifiable by their gender identity, a characteristic also protected under the SDA. I have determined that endorsing overt acts of discrimination cannot be the intended effect of the exemption power in the SDA. So, if female lesbians want to publicly organise without men who claim to be lesbians, that is improperly discriminating against those men. The decision affirms that in Australia, the Sex Discrimination Act does not protect the rights of an individual to biological sex-based protection or sexual orientation rights in a way that excludes people of the opposite biological sex based on their gender identity. Now, this is not the only way that the Act can be interpreted because it does not say this explicitly, but it is the way that the Act is being interpreted. This, in practice, gives the protected characteristic of gender identity a status higher than that of sex and sexual orientation. It creates a de facto hierarchy of protected attributes. LAG has 28 days from the date of the decision to consider whether it wants to appeal, and we will update you. If you want to support the Feminist Legal Clinic, it is the only legal service in Australia that is a signatory to the Declaration and that has a statement on biological sex, and it receives no funding or council premises, so it runs entirely on donations. Thank you very much.
I'm pleased to announce that this Thursday at 8 p.m. EST, our new anti-pornography working group will be hosting a live webinar in recognition of January as National Human Trafficking Prevention Month. Panelists, including Ellie Arrow, Aaron Brewer, and Melissa Farley, will discuss their efforts to combat the sexual exploitation of women and girls, with WDI USA Chief of Staff Kristen Zabrowski serving as facilitator. I'll share a link that includes more details about the event, including the registration link in the chat. In response to last week's House vote on the Protection of Women and Girls in Sports Act, we published a statement that concludes with the following paragraph. Representatives Moulton and Swazi should have made history yesterday by voting yes on the Protection of Women and Girls in Sports Act, thereby becoming the first Democrats to protect the sex-based rights of women and girls at the federal level. We're grateful that Representatives Cuellar and Gonzalez bucked the party trend and did the right thing by voting to protect the sex-based rights of women and girls. We also published new commentary contributed by our Lesbian Caucus. The piece titled, Lesbianism, Can Symmetry and Equality Be Revolutionary and Sexy Too?, thoroughly deconstructs the opposites attract doctrine and other associated patriarchal influences within lesbian culture. Moving on, the newly rebranded People's March, formerly known as the Women's March, took place over the weekend. Board member Irene Lawrence and other WDI USA volunteers attended the event in Washington, D.C. There they handed out business cards and had some positive conversations about women's sex-based rights. Anna Heinrichsen, our California state contact, joined activist group Women Are Real and other TERFs in San Francisco to remind attendees that a woman is an adult human female. Brittany Watts, an Ohio woman who in 2023 suffered a miscarriage at home and was later falsely charged with felony abuse of a corpse, has filed a federal lawsuit against the hospital and healthcare providers who treated her, as well as the police and the city of Warren for their role in criminalizing her pregnancy loss. Watts was denied an abortion at just under 22 weeks of pregnancy, despite being told her fetus was not viable and that she was at risk of hemorrhage, sepsis, and death until the fetus was removed, according to the suit. While Watts was eventually cleared by a grand jury, the harm remains, and she now seeks redress for defendants' misdeeds and to hold them accountable. A few weeks ago, I mentioned that on January 14th, a district court judge would hear the complaint brought by Rhonda Fleming, a female housed in the U.S. Bureau of Prison System, to decide whether she has a right to bodily privacy from male inmates. Unfortunately, Single Sex USA reported that the judge ruled against Ms. Fleming's claim. The organization hopes to provide more detail on the ruling once they have had an opportunity to review a transcript of the proceedings. And while we're on the subject of men and women's prisons, SB 1049, a bill similar to California's notorious SB 132, requiring that prisoners be housed on the basis of self-declared gender identity rather than sex, has been introduced to the New York State Senate. The submission by Keep Prison Single Sec USA Director Amanda Stillman, in opposition to the bill, concludes as follows. Despite claims to the contrary, it is not a human rights violation for male inmates, however they self-identify, to be denied access to showering with and sharing toilets and sleeping quarters with an already traumatized population of incarcerated women. Consistent with New York's obligation to protect the rights of incarcerated women in its custody, we ask that you reject Senate Bill 1049. In yet another move that should surprise no one, the Democratic Women's Caucus now includes men, with the addition of newly elected Representative Sarah, aka Tim McBride. And finally, yesterday was Inauguration Day for President Trump, and he was expected to sign nearly 200 Day One executive actions, including an expansive order called Defending Women from Gender Ideology Extremism and Restoring Biological Truth to the Federal Government. According to the Free Press, who got a sneak peek, the executive order establishes government-wide recognition of the biological reality of two sexes, ends the practice of housing men in women's prisons and taxpayer-funded transitions for male prisoners, ends the forced recitation of preferred pronouns, and protects Americans' First Amendment and statutory rights to recognize the biological and binary nature of sex. Trump's order seems to be an excellent start for an administration that claims to be intent on restoring the sex-based rights of women and girls in federal law and policy. Despite the legal wrangling, it and others to follow will no doubt engender. American TERFs are encouraged that adult human females appear to be deserving of protection, dignity, fairness, and safety to our federal government again. Kara wrote a preliminary analysis of the executive order in a Substack post published this morning, which discusses its limitations, and I'm so glad she is here today to speak more about it and answer any questions you may have. That's all I have today. Thank you.